I'm finishing a book called Birthright Citizens, which is a look at the history of race and citizenship in a somewhat unexplored period, that is the period before the U.S. Civil War, the period before the amendment of the Constitution, with the 14th Amendment providing birthright citizenship for the first time in the United States. My case study is free African Americans, former slaves, and their descendants, all with a mind toward understanding how, as a nation, we grapple with people who occupy this in-between status, neither slaves nor fully free citizens. How in law do we regard those people? Most often that story is told through a somewhat notorious U.S. Supreme Court case called Dred Scott versus Sanford, in which the court, through Roger Taney, declaims that no black person can be a citizen of the United States. But it turns out that while Taney was quite sure about his ideas, he really was just one volley in what was an extended debate about race and citizenship before the Civil War. So for me, the story begins in the 1820s with free African American activists themselves, who through local courthouses and in high court arguments, in legislatures and in political conventions, again and again make the argument that they are citizens of the United States, again and again make the argument that by virtue of birthright, by virtue of their military service, and by virtue of their contributions to the economic prosperity of the nation, they should be citizens. It's an important chapter in part because it tells a new version of the 14th Amendment, which was not merely a creature of the U.S. Senate, but actually came out of the activism of free African Americans themselves.